Looks like it's 1 o'clock. If we could bring the meeting to order, that'd be great. Okay, this is Shane Doherty, the presiding officer. It's 1 o'clock. Would like to call the meeting to order and basically do a roll call. And at this time, we want to start to the left here.
Gary Ernest, Tyler County.
Sidney Villa, Jim Wells County.
Shane Doherty, Dallas Central Appraisal District.
Tim Radloff, Lubbock Central Appraisal District.
Mike McDougall, public member from Lubbock, Texas.
Okay, we have a quorum. Let's move on to item C, training for committee members. I want to pass that over to TDLR at this time. Mark Gladney.
Good afternoon, board members. For the record, my name is Mark Gladney, Assistant General Counsel. Today we're going to do a little bit of training on the Open Meetings Act, the Public Information Act, which is also known as the Open Records Act, and the Administrative Procedures Act.
Okay. Good thing it's on, because I got a little touch of laryngitis, so I really do need this. Okay. This training we do for advisory groups on an annual basis, so you all haven't had it, I believe, since probably last year, so you're definitely due. So with no further ado, we're going to get started. As I said, this training overview is on the Open Meetings Act, which you're going to find in Chapter 551 of the Texas Government Code, the Administrative Procedure Act, and you'll find that in Chapter 2001 of the Texas Government Code, and then the Public Information Act, and you'll find that in Chapter 552 of the Government Code if you're interested in looking at the entire text. Okay, we're going to start with the Open Meetings Act. And basically, the purpose of the Open Meetings Act is to ensure open and transparent government. And you're going to hear that throughout this entire presentation about openness and transparency. And the Act requires that meetings of governmental bodies be open to the public and to be preceded by public notice of the time, place, and subject matter that you all are going to be talking about during the meeting. The Act it's mandatory. We have to follow this act. And if there's any questions about the act, any legal questions that arise about the act are going to be construed in favor of open and transparent government. All right, so this is also known as just putting sunshine on governmental deliberations, so the public knows what their officials are doing and they can provide input. Now, I'm sure you all know what a quorum is, but basically a quorum, which you all have determined that you have here today, is a majority of members of the advisory board or committee that's fixed by rules or statute. So in this particular group, a minimum of 4 would constitute a quorum. And a quorum of governmental bodies, such as this committee, must be present in order to make an official action. If a quorum isn't present, then the board or committee may meet and discuss, but they cannot take any formal actions. Now, deliberation or discussion is just basically y'all just talking about items that are on the agenda. So it's just an exchange amongst y'all between a quorum of the committee or between a quorum of a governmental body and another person concerning an issue that's within the jurisdiction of governmental body or any public business. Okay, now a meeting occurs anytime that a quorum of the committee engages in any discussions regarding public business or public policy over which the committee has supervision or control, or any time that y'all take formal action. So basically, the meeting has to be about basically PTPs and the issues that surround that in order for it to be considered a meeting under the Open Meetings Act. Now, very important, must be notice of the meeting. Now, and the public has to have advance notice of the time, place, date and subject of each meeting held. And that's why we have an agenda, so the public has that knowledge of what y'all are going to be discussing at the particular day and date. The notice has to be filed with the Secretary of State not less than 7 days prior to the meeting, and must be posted, and we post it on our website, and the Secretary of State does as well. Now, very important, the board or committee may not engage in discussions about a subject that's not included on the agenda. And there will be times when we have an agenda item and y'all may start talking about something that's ancillary to the agenda item. If you do that and you're kind of straying off of the subject matter that's been noticed in the agenda, you're probably going to hear from me saying, you're probably straying a little bit off the reservation, and we need to move back into the subject matter of the agenda item. So that's probably the only time, one of the few times you'll get a nudge from me on something of that nature. Now, if you want to discuss that particular issue that was brought up during that agenda item, but it wasn't posted, then my suggestion to you would be, well, why don't we just put it on for a future agenda item?
And Mark, that also includes public comments as well, right? Responding to public comments?
Yeah, for public comment, those items are not on the agenda. So the person comes up here for 2 or 3 minutes, discusses an item during public comment that's not on the agenda. You don't respond. And sometimes folks don't understand that, and we'll usually try to tell them that you cannot respond to an item that's not on the agenda. So they don't think that you're not listening to them. You're actually listening to them, but by law, you cannot respond to an issue that's not formally posted on the agenda. Okay? Alrighty. Now, what about social functions and conventions and workshops? Now, as we discussed, a meeting occurs whenever a quorum of a governmental body engages in discussions about public business. Can you all ever meet in an informal session and not violate the Open Meetings Act? Yeah, you can. You all might be at a convention or a seminar or something of that nature, and you're free to discuss, have conversations that are purely incidental to the event. However, the gathering would be subject to the Open Meetings Act if a quorum of the members are there, and the members either start talking about an item about over which you all have jurisdiction, or take formal action. So, basically the best thing to remember is just be aware in situations where there may be a quorum of y'all at. Just be very careful about what it is that you're talking about. Don't engage in any substantive conversations relating to board or committee business or policy when a quorum is present and you're outside of a regularly scheduled member. So the best thing is, if you're in those situations, just avoid it. Avoid those kind of discussions. If there's any official business that needs to be done, it needs to be done in this room after it's been properly noticed and there's an agenda for the items that you wish to discuss. So that's the safest thing. Now, here's where we get to what's known as a walking quorum. And, believe it or not, this kind of happens a little bit more than you kind of like to see it happen. I've been on boards myself and on committees, and it's pretty easy for it to happen, but you don't really want this to happen because it can cause a heck of a lot of problems. A walking quorum occurs when fewer than a quorum of members engage in discussions about official business and then talk about those discussions to other members. So basically, this is a 7-member advisory board. So let's say 3 of y'all exchange phone calls or emails expressing thoughts on an upcoming rule change and exchange information that y'all have gathered through your own individual research about the issue. Well, so there's 3 of you that are doing this. Okay, well, one of you decides you're going to talk about what occurred in that phone conversation with a 4th person, and maybe even exchange that information. At that point, you've engaged in a walking quorum, by engaging in a small group discussion outside a properly noticed meeting. And that's wrong. Cannot do that. So walking quorums can occur during conference calls, video conferences, hallway discussions, emails, and text messages. And one of the biggest things where you can run afoul of this is with social media. So, with Twitter and Facebook, you put some posts out there about an item, and your Facebook friends may be some of the folks that are sitting right here. You can easily get into a situation where you've got a walking quorum just by posting something innocently, and you forget about the idea of walking quorum. So being extra careful, again, I'd say that's something that you all need to avoid, because you would be in violation of the Open Meetings Act. So do everything you can to avoid walking quorum. Best practices. To avoid a walking quorum, members should not meet in small groups, discuss board or committee business, and then communicate those discussions to other members. We just talked about that. Don't send emails or text messages to a quorum of members regarding official business, even if you're sending them to the person individually, not as a group of the 7 of you. Right now, it'd be 6. Just don't do it. Again, don't put posts on social media about board business where it's likely that a quorum of members could actually see that. Don't do that. And don't ask a quorum of members, even on an individual basis, for comments on board or committee business outside the public meeting. That's called polling. Again, that's a no-no too. So these are things that we strongly suggest that you avoid doing. Yeah. Again, if you want to do any official business, do it in this room. Okay. Okay. The guidelines for open sessions. As I said, the board is limited to discussing specific items on the agenda. I've said that several times. I say that several times because a lot of times folks just sometimes will stray and talk about things that aren't necessarily on the agenda. So it's my job to try to keep you on the straight and narrow and not roam off the reservation. So that's an important thing to do. What's on the agenda is what we need to be talking about. Okay. During the public comment period, members of the public are given an opportunity to speak. Generally, it's 2 to 3 minutes. I've seen some boards give a little bit more time. And you can certainly set whatever limit that you deem reasonable. These are items that are not on the agenda, so the committee is prohibited from responding directly to them, other than to suggest that they be placed on the agenda for a future meeting. And we do have provisions in the agenda for future agenda items. Okay. Again, best practices, as we said, limit discussions to specific agenda items. Avoid wandering off course on the agenda items. Don't respond to issues that are raised during public comment. And specifically identify items for future agendas and communicate those items to staff. And in this agenda, we have agenda item number I. We routinely put this in here, recommendations for agenda items for next committee meetings. That'll be your place to put in whatever it is that you want to see on the next agenda item. And, board support will, take care of that, and we'll make notations, and we'll see that those are placed on the next agenda for your next upcoming meeting. All right. Now, it wouldn't be much of a law if it didn't have some penalties attached to it. This one has some civil remedies, and if the committee takes any actions, any formal actions that are in violations of the Open Meetings Act, they can go into district court and get a injunctive relief. So either a TRO and then a temporary injunction, maybe moving to a permanent injunction to stop whatever action that they deem to be improperly done by the committee, and if a judge agrees with them. Any action that's done by the committee that's in violation of the Open Meetings Act is voidable. It's not void from the very beginning, but if somebody brings an action against the committee for engaging in action that's in violation of the Open Meetings Act, that formal action can be voided out by court. Okay? There apparently are some criminal penalties too, although I don't think I've ever seen anybody actually, be subject to these, but it doesn't mean that couldn't happen. So members who knowingly conspire, and the key word here is knowingly. It's not a strict liability offense like, say, a traffic violation. If you go through a stoplight, that the action itself, you don't have to show that there's any kind of mental state associated with you going through the stop sign. The fact that you did it, that's a strict liability offense. Here, they require a mental state. The mental state would be knowingly conspire to circumvent the Open Meetings Act. You're subject to misdemeanor criminal penalties anywhere from $100 to $500 up to 6 months in jail. So, as I said, I don't think I've ever seen that in over 30 years of practice, but you never can tell. And it's our job to make sure that we let you know that that's a possibility. Okay? Okay, so avoid communications that involve a quorum of members about official business outside a properly noticed meeting. And during the meeting, just combine your discussions to what's on the agenda. Okay, now if you want to, you have some extra time to kill, and you want to look some of this stuff up, we've given you all the sites that you can go on the internet, and you can find the Open Meetings Handbook from the Attorney General, the Open Meetings Training information and video, and I strongly urge you to go to that particular site. There's a 1-hour video for open meetings. There's a 1-hour video for the Public Information Act. If you take those and you complete them, you get a certificate. Yeah. So strongly urge you to go and do both. Okay, and if you have any questions, you can get a hold of us at the number below, and I put my number, my personal number or my office number on there as well. Okay. Okay, now we're going to move to the Administrative Procedures Act. As you can see, the purpose of the APA is establish minimum standards of uniform practice and procedure for state agencies and to provide public participation and transparency. There's that word again, transparency, during the rulemaking process. And a rule is basically a statement that's made by a state agency that implements and interprets law or policy or describes the practice or procedure requirements of a state agency. So a law, you can think of a law kind of as a framework, the outer boundaries of what can and cannot be done. But sometimes, like if you look at it like kind of like a picture frame, sometimes laws themselves, they can be very explicit, very specific, and in some cases they can be kind of vague. And what a rule does, it kind of fills in that picture that's a little bit blurry. And the rule interprets the laws in that particular sense that are a bit blurry. But rules have to have a basis in authority under statute. You just can't create a rule without the basis, the underlying basis of a law. Okay? And a rule can include an amendment or repeal of a prior rule, and it doesn't have to solely relate to the internal processes, management, or organization of a state agency. And this is where you can find your sources for rulemaking. People come up with ideas, and rules start out as ideas. Yeah. And they can come from legislative changes, advisory board work groups, even your discussion here today. Rules can come out of that. They can come from staff. We also have a 4-year rule review that's required by law. In fact, PTP is in the throes of a 4-year rule review as we speak. And then also you can have a rule petition from an interested person or a member of the public. So for a rule petition, it says any interested person can petition a state agency to request the adoption of a rule. And here's all the people that are designated as interested persons, so anywhere from a resident all the way up to a private organization that's residing in Texas. And this is basically the process. Again, rules start out as ideas. So we have an idea for a rule. Then we draft it, usually with the help of a work group, and usually with the advisory board members in the work group as well. And then we come back for an advisory board meeting. The draft rules are sent to y'all for consideration. And if you recommend publication, the proposed rules are filed with the Texas Register for publication. And the public has 30 days to comment on those proposed rules. Okay, and then we review them and we recommend rule changes. We come back to you all and we review those comments and we ask for y'all to make a recommendation to adopt to the commission. And then it goes to the commission at one of their formally noticed meetings, and they review the comments and the recommendations that come from the public and from you, and they adopt the rules. The adoption is filed with the Texas Register, and 20 days after they're filed with the Texas Register, they become effective. Okay? This is the rule review process. As I said, every 4 years, all the rules go through a review process. And basically what we're looking for is, are the rules still necessary? Now, that's the phase 1 process. Are the rules necessary? We file a notice of intent to review with the Texas Register. And again, the public has 30 days to comment on that. We review the comments and we make a recommendation to the commission. The commission reviews the rule filing and comments, and more often than not, they're going to re-adopt the rule. Okay? And the advisory board will be presented any comments, and they may recommend some changes. That's the phase 1 process. Are the rules still necessary for the administration of the profession? Phase 2 is the formal rulemaking process. This is phase 2. Okay? Okay, and again, you know, if you're really feeling eager, here's all the links for you, and you can take a look at them, and who knows, you can become an expert on this, and you know, do whatever you're going to do with that. Yeah. Okay. Now we're on to the Public Information Act, also known as the Open Records Act. And the Open Records Act is intended to allow each person information about the affairs of government and the official acts of public officials and employees. The Act makes all documents, records, and other information relating to official business open to the public with some exceptions. Again, this is all along the lines of sunshine on government. Yeah. All these things, all 3 of these items that we're talking about, all discuss, and they all relate to sunshine on government. Okay, public information includes any electronic communication created, transmitted, received, or maintained on any device if it's in connection with official business. And that's kind of an important little item there, and we're going to talk about that a little bit more in a few minutes. So, if you all happen to receive a public information request, forward it to us, you know, to the General Counsel's office as soon as you get it. And you know, we may get a hold of you and say, hey, you know, we might need some information from you. And if you do get an inquiry from us, please respond as quickly as you can, because we only have 10 days to respond to this. We can't ask for why anybody wants the records. We can only ask for clarifications if their request is confusing or overly broad or something of that nature. We can certainly ask for that, but we can't ask the reason why they want these things. And as you can see, there's certain items that are not subject to disclosure, and the list is very long, but we just kind of gave you just a few there: date of birth, email, certain education documents, and certainly anything that's related to HIPAA and health records. Those things are going to be accepted from disclosure as well. Okay, so again, if you want to know more about the PIA, here are the resources that you would need to know. Now, going back a little bit, this little item right here, public info. Ooh, what's happened there? I guess if you touch it, okay. Public information includes any electronic communication that's created, transmitted, received, or maintained on any device, if it's connection with official business. Your personal devices. You must be very, very careful about how you use your personal devices. If you're using them for official business, they can become subject to an open records request. And I wouldn't think that you'd want your personal devices, anybody going through those things, or you having to give up any information that may or may not have anything to do with official business. That's your personal device. It's got your personal information in it. So do everything that you possibly can do to not use your personal devices to conduct official business. So that's why I kind of pointed that one out as much as I do. So be very careful. I've seen that happen. So that's pretty much it for the presentation. Are there any questions?
Excellent presentation.
Well, thank you very much.
Appreciate
I always
it.
like it when
You know-
y'all don't have too many questions.
Well, as we got 4 public officials up here that are board directors, we get a lot of Public Information Act, open records requests in our office, but it's good to have this all reinforced, so.
Well, thank
we
you very much,
appreciate that.
gentlemen. I really appreciate it.
Thanks. All right, well, let's move on to item D, approval of minutes. Our last meeting was held on June 15th, 2017. If we could review those, I'm sure you all reviewed them in advance, and get a motion to approve.
I'll make the motion. Sydneyville, I'll make the motion to approve the minutes as presented.
I'll second Tim Radloff.
I was going to question that because I saw James. I didn't know that's your official first name, though. huh?
Yes, that's-
Okay,
I go by
threw-
Tim.
Okay, I thought they were throwing me off to see if we really read them. And I was going to correct that, but
It is,
appreciate that.
yes,
All
that's
right,
my
well,
given name.
Motion passes. Any comments? All right, good deal. Let's go to item E, which are public comments. I don't know if anybody filled out forms. Do we have any? So no public comments at this time. Let's go to item F, which is staff reports. TDLR will provide us their staff reports and discussions. Appreciate that. First one up is licensing division.
Good afternoon. I am Michelle Thomas, and I'm here with Sam Torres. We are the team leads for the Blazers team in licensing. Our team processes the application and renewals for the PTP license types. We are presenting the licensing statistics report on behalf of our manager, Tasha Ray.
The first one is Sam Torres, licensing. The first one is appraisers, and you'll see the total population is 2,813. Of those, the new licenses were 323, which is about a 34% increase over the fiscal 2017. And then the renewed licenses issued was 2,659.
Michelle Thomas. For the collector license type, the total population of licenses issued for fiscal year 2018 is 172. Of that figure, 19 of those issued licenses are new licenses, a 50% increase from fiscal year 2017. The remainder of the total population figure is for renewals, for which we saw an increase of 9 for fiscal year 2018. And please bear in mind that the population number represents a snapshot of the number of active licenses on the last day of the month of August.
And then for the assessor collector, I'm sorry, Sam Torres is for the assessor collector, you have a total population of 622. New licenses issued, about 19 licenses over 2017, and your renewed licenses were 568. So the total population with all three of these at that time is 3,607. And if you have any questions, hopefully we can answer those for you.
Any questions? I have one that just struck me as unusual. Is in the fiscal year 17, I'm assuming your fiscal year is September 1 through August 31st?
Correct.
Okay. I just thought it was interesting that the renewal licenses in 17, there seems to be an anomaly with both the appraisers and the assessor collectors. I didn't know.
Well, all three.
Yeah, exactly, exactly. It seems that like just something that TDR might want to look at. I would think those numbers would be consistent from year to year. For instance, in 16, we had 2,602 renewed licenses for appraisers. In 17, it went to 1,676, and then back in 18, it's back up to 2,659. So that seems a little strange. I would think that those numbers
Would be a little more consistent.
Consistent. So something that stood out to me when I looked at this, but it is. I do know we have approximately 3,800 registrants across the industry, and I do think the appraisals industry will continue to grow. The assessor collectors, that's probably going to be flat to down, as some of the city and school district offices may go to the county assessor collector. But that's just something that I noted when reviewing these stats. So maybe you could address next meeting. So perfect.
Okay.
It's good. Good report though. Thanks.
Thank you.
Thank you.
Okay, we're up to number 2 is Customer Service Division under TDLR staff reports.
Hello.
Hello.
Good afternoon, committee members. My name is Misty Maldonado de Leon. I am the manager for customer service for this industry. As you can see, the report in front of you, of course, it's for the whole fiscal year. We hadn't met since last year, so it's pretty telling of how many emails this industry likes to send as opposed to phone calls, which is better. We prefer that. It gives us time to look a little more into the details and give you more accurate answers, and it's also documented. So I just wanted to add for the industry, since it's been that long since we met, the hours for the contact center are 7 a.m. to 6 p.m. Monday through Friday. We do prefer the emails to the cs.tax.professionals@tdlr.texas.gov, and those get answered within 24 to 48 hours. We have added the renew online on that landing page, so that's also something that's been helpful. And they have an option to sign up for email updates on that page as well. And that concludes my report, unless you have questions on statistics.
Appreciate it. We're getting anywhere from about 130 calls, 130 emails a month. I know the 24-hour turnaround is great, and I do agree. I know as officers too, we want to encourage people to put it in writing as
Yes.
opposed to calls. I mean, that's the better way. Have it in writing. Get the facts down, and then you can properly respond. So.
Right.
When somebody does call, do they get someone right away, or do they typically have to leave a callback number?
We do have a callback feature. I'm glad you mentioned that, because I forgot to mention that. But we do have a callback feature. We do also have a recording while they're holding to send an email to either help or their industry. So we also have a help email box if they don't want to continue holding as well. But they do go through the 800 number, so they do have to wait, as all the other industries do, so it takes a little longer.
Gary Ernest, do you track recurring questions or maybe isolate concerns based on a common denominator or any part of the questions that they ask during the customer service?
We have recently started doing that for our bigger industries. This industry, we have subject matter experts that, because it's smaller, we just, they have those statistics, so I could definitely get that for you.
Great report. Thanks.
You're welcome.
Okay, we're on to number 3 under staff reports, Enforcement Division.
Good afternoon. I'm Dawn Burton, prosecutor in the Enforcement Division, presenting today's staff report. Since you last met, the Enforcement Division has hired staff and also reassigned some prosecutors. Our new intake manager is Cheryl Wilson. She manages the section that receives complaints in the Enforcement Division. Our new prosecutors are Aaron Heath, Bob Rennick, Rebecca Burkhalter, Robert Reyes, and Tony Reed. Aaron Heath is the prosecutor who's now assigned to prosecute the cases in this program, and Rebecca Burkhalter or I will be the person presenting staff reports in the future. As you've undoubtedly seen in your past staff reports, the enforcement statistics in this program have consistently remained low, and most of that is attributed, besides the fact that there's a smaller regulated entity base in this program, a lot of that is attributed to the fact that most, or many at least, of the professionals work for governmental agencies and just tend to be more likely to be law-abiding citizens. And for example, in 2016 and 2017, in each of those years, there was only one agreed order in each of those years. And in 2018, there were no agreed orders, which is why we don't have any case highlights for you today. Did you have any questions about the staff report? Or I'm available for any other questions.
Sydneyville, a question. How long does the typical case take to get resolved one way or another?
I would need to check on that in this program. I'm not sure. I can get that for you for your next meeting.
I'm just curious from the time it gets filed until it gets resolved.
Now,
the time frame
when we
is.
say resolved, there are most of the cases are resolved through informal means, and those get resolved very quickly. Those can get resolved in a few days. Agreed orders would take a lot longer time, but I can find out what the average is. Or
Yeah, and maybe for the next meeting as a possible agenda item is talk about the intake. There's like a 5-stage process. I know some of us who sat here originally talks about what happens when there's a complaint filed, and maybe something good to do, bring other people up to speed on the board about how that process works.
Okay.
And maybe address it at that time as well.
Okay. I can state that just generally speaking, we'll provide more later, but generally speaking, when a complaint comes in, that complaint is reviewed through the staff in the intake section, and if there's enough information to open a complaint, open a case, then that case is opened and assigned to an investigator. When that investigation is completed, then it's assigned to the prosecutor, who can close it with a closing, a warning, or can issue a notice of alleged violation. And from there, then there are 3 types of orders: the agreed order, default order, or a final order from the commission.
Well, there you go. I think that's it. I don't know if we need it next. That's pretty much. So it's good to know, though, because we time get questions about that. It's great.
Anything else?
Well, I'm proud of our industry. You know,
Yes.
like to see 0 complaints, but I don't think that's realistic in the job that we do. But I think relative to the other industries, I think we have a good body of people within our industry, and we are following the laws set forth. So appreciate the reports.
Thank you.
Okay, we're on to item 4, Education Examination Division.
Good afternoon, Mr. Chairman, members of the board. I'm Ray Pizarro, Director for the Education Examination Division. Yeah, it's been a while. We haven't seen each other in a while. We've seen each other October 10th, but the agency has changed. Our division has changed. We continue to grow as a division and as an agency, and you probably hear a lot about that as we move on through the meeting. But just a few things. The last ERC we had was some time ago. We're not going to have another one until probably after the session, because as you know, some of we like to get those statute changes incorporated within the examinations, and we don't like to rush things on that. So we'll probably have that sometime in November of next year. We consistently have right around 500 exams for this industry yearly, and we review about 1,000 courses. But as we continue to grow as an agency, back when, gosh, we've been together now, what, 10 years? This arranged marriage been 10 years?
Exactly.
And since then, when we started, we were, as an agency, we're administering over 48,000 exams a year. Today, we're up to 67,000. So that's quite a bit of change. Doesn't necessarily impact your industry, but you can see the amount of change in resources and the way we do things as security and exams and the different things that we need to do to ensure that we maintain that compliance and that level of efficiency. We attended the PTAD meeting on October 10th. I'm not going to steal any Russ's thunder, but he'll give you some more information on the mapping report. But basically, my presentation there was to talk about the growth of the agency, where we're moving, and how things are going. We'll continue to grow, as I said, and we'll probably get more additional industries. But our focus with you guys is to ensure that we do not lose sight of our dear friends, PTP guys, that we maintain the level of performance that we have been for you all. For those who are new to the board, Mr. Ernest, Brian's not here, but if you look at some of the statistics, you may wonder on, for example, on the exams, you may wonder on what those numbers really mean. Just keep in mind what you're looking at are attempts. They're not people. It is just an attempt of how many times somebody have made who've taken that exam. So the statistics are what they are. We don't look at them as it's 54%, oh, it's too hard, we need to make it easier, or if it's 90%, it's too easy, we need to make it harder. They are what they are. We have subject matter experts who help us develop those exams and maintain the exams to ensure that what we're asking are the right things to get that minimally competent person a license. So that's kind of how that works. I don't have anything else for you guys, but if you do have any questions for me, I'll be happy to answer them.
And when he referred to ERC, it's Examination Review Committee, and that's reviewing it. So, it is interesting. We tend to have a little bit better pass rate for the appraisers than the assessor collectors.
Yes.
But again, we have subject matter experts that are looking at this and feel that the exams do meet the minimum level of competency.
Yeah.
And they're sufficient to, so we, it's.
And we as an agency, we really want to have some of the board members involved. And so if you are one of those who want to be part of that subject matter expert,
It is interesting, we're less than
feel
1%
free.
of the total exams taken within the TDLR department.
yeah,
So that's
well,
pretty-
looking
that's
at the
pretty
numbers, it
interesting.
is.
That's pretty
It's, yeah, it is.
Thanks for the report.
Yeah.
Appreciate it.
Yeah.
Thank you.
All right, we're on to Staff Report 5, Regulatory Program Management Division. That's a mouthful. So that's recently changed.
Yes, sir. Good afternoon, committee members. I'm Russell Tolley, the program specialist in now the RPM division. Since we last met, what was the compliance division has been reorganized and renamed. I'd like to introduce our new director, David Gonzalez, here, and his deputy director, Lee Parham. David and Lee are longtime compliance, now RPM management. RPM is now divided further into separate teams. Charlotte Melder, who's not here today, is new to the RPM division, but she's a longtime employee of TDLR. She's an attorney from our enforcement division. And I remain the program specialist for PTP. I'll give you a brief interview. Part of my annual duties includes checking up on the methods and assistance program, the reviews that the comptroller's office does annually. Every year they review one half of the county CADs, complete a MAPS report. Those counties then have 1 year to resolve any issues or deficiencies that the comptroller's office finds. If they don't, within that 1 year period, complete or resolve those issues, are referred to us, and they work with us for a year to go ahead and complete those deficiencies. Last year we had 4 counties referred to us. All of them resolved their deficiencies in the year. This year we've had 17 counties referred to us. Those are listed in the report that are included in your meeting materials. I do have one update. In addition to Maverick, Presidio, San Patricio, and Terry counties who have completed their resolution of issues. I'd like to add Collingsworth and Anderson to those. So this time of year, they continue working on their processes and getting information to me, and I'm going through those documents now at that time. Like Ray said, we did attend the TAD, PTAD, TDLR Liaison Committee on October 10th. I was there basically to give an update on the MAPS program for this year. Ray was able to provide information on our enforcement activities. As the program specialist, I'm available for any future liaison committee meetings or any outreach programs you have. For other programs that I work with, sometimes that's an annual convention of an association or just a regional group meeting. I'd be willing to participate as an informational resource to any meeting you might suggest. And that concludes my report.
Any questions? Well, for those in the audience and watching the video, we have 253 appraisal districts. So in 17, to have only 4 and all been resolved, that's pretty good. Says a lot about the industry again. And I'm sure there's still due diligence going on with the 17 or now 12 under review.
Correct.
And overall, you feel like most of the CADs are coming up to speed that are pushed to you for MAP?
Absolutely. Most of them only have 1 or 2 issues that are referred to us, and some of those are maybe they missed a time deadline in previous year, and now they've simply committed to meeting those deadlines going forward. So,
thanks for the report. All right, we're on to executive office report.
Yes, sir. Mr. Chairman, advisory board members, Nick Voinis, TDLR Chief of Staff. Thank you for being here today. We appreciate your service. Also want to introduce to you one of our commissioners, Dr. Gary Wesson, who's here visiting today.
Thanks for showing up. Appreciate it.
But so I'm here to kind of give you a summary of what's been happening around the agency since you guys last met in June. This summer we completed our strategic plan, and it's something that the legislature mandates all state agencies do every 2 years. And it's something we take very seriously. We hosted internal and external sessions that served as an opportunity for everyone to come and share ideas and opinions on how we're doing and how we can improve on managing our programs. The final report was completed and submitted to the Office of the Governor and the Legislative Budget Board. It's available for viewing on tdlr.texas.gov. Pertaining to your program, there's one item from the plan that legislators will consider, and that is to move all of our 1-year licenses for individuals to 2 years, including yours. So we'll wait and see how that works out in the legislature. Following our work on our strategic plan, the staff went to work on our legislative appropriations request. And that report was done and submitted to the governor's office and the LBB, and it too is available for viewing on tdlr.texas.gov. We've been busy participating in interim legislative hearings as well. Last week, our executive director, Brian Francis, testified at a hearing of the House Committee on Licensing and Administrative Procedures. Went very well. Prior to that, TDLR presented at a joint hearing of the House Committee on Licensing and Administrative Procedures and the House Committee on Business and Industry. We also testified at a joint hearing of the Governor's Budget Office and the LBB, as well as hearings of the Senate Business and Commerce Committee and the House Natural Resources Committee. All this in preparation for the upcoming next legislative session in January. Also wanted to talk to you a little bit about outreach pertaining to your program and some traffic numbers associated with your website and other outreach efforts. Over the last 6 months, the Property Tax Professionals webpage has had 26,464 page views. That's an average of 144 per day. Of those folks that access your site, 81% did so from a desktop, while 19% did so from a mobile device, including 16 from a smartphone and 3% from a tablet. The top reasons for visiting your site are the Property Tax Professionals core education, followed by the continuing education information. So, and in addition to your web presence, also want to remind you that TDLR is active on Facebook and Twitter, so you can keep up with with agency events and news through that social media, through our social media efforts. Also wanted to mention that you guys have a group of 8,200 subscribers that receive various email blasts pertaining to the program. And if anyone is not receiving those and would like to, they simply could go to our website, tdlr.texas.gov, and sign up, and they'll immediately start receiving those. So, if you have any questions, be glad to answer them. Otherwise, thank you very much.
Yes, sir. I had one question. Sidney Villa, you mentioned that one of the considerations for the legislature was maybe changing the license to a 2-year as opposed to a 1-year?
Yes, sir.
And how many continuing education credits were you looking at? Right now, we're having to get 30 every year. Would it go to 60 in 2 years?
So it's 30 every 2 years.
Well, 30 every 2 years, excuse
Right.
me. So would that be the same, or would that change if it goes to 2 years?
Stays the same.
Stays the same, good.
Okay. Interesting. You said that's going forth possibly legislatively as a
Right.
change. Okay. Great.
Thank you.
Any questions? Okay. Well, appreciate the TLO staff reports. It's good to get updated. We're going to go to agenda item G, discussion on rule review of 16 in Texas Administrative Code, Chapter 94, which is being conducted in accordance with the requirements of the Texas Government Code 2000.039 and all public comments received. So we're going to get a report for TDLR.
For the record, Mark Gladney, General Counsel's Office. All right, the agenda item number G, again, is dealing with the Phase 1 rule review that we discussed earlier today. Currently, PTP is in the 4-year rule review, and again, that's to determine whether or not the rules are still necessary for the administration of the program. The government code requires the state agencies review these rules every 4 years. And the department has reviewed these rules and determined that the rules are still essential for implementing the statutory provisions of Chapter 1151 of the Occupations Code. The rules provide details that are not found in the program statute, but are necessary for the implementation and operation of the program. The notice of intent to review the rules was published in the Texas Register on August 24th, and the public comment period closed on September 24th. The department received 3 public comments on the notice of intent to review. The first commenter suggested the Ethics and Uniform Standards of Property Appraisal Practice, UPAP, courses be completed every 5 years instead of the current requirement of every 2 years, as there is little change in course content over the subsequent years. The commenter further proposed the inclusion of continuing education courses, ineffective age and property depreciation, and instruction on unequal and uniformity. Lastly, the commenter opined that the Office of Texas Comptroller of Public Accounts consider updating curriculum for the RPA courses. The second commenter questioned the need for the 60-month registration prerequisite for a Class 4 RTA under Rule 9421. The commenter noted that if the licensee is promoted to a top license type but does not have the required 60-month registration time, an appraisal district would not be able to fill the position timely or would have to temporarily retain an individual with the required license type until the desired candidate reaches the 60-month registration threshold. Such a practice, the commenter contended, could result in unnecessary expense in smaller taxing districts. The commenter who possesses an RPA license suggests that the department should consider a rule to allow waiver of the 60-month requirement if the applicant is currently employed with an appraisal district and holds another PTP license type. And then the last commenter supported the readoption of the rules as they exist. Today, the agenda item is simply just for discussion. No action is required to be taken by y'all.
Any questions? I'm curious, Shane Doherty, if relative to the public input to your other industries, I mean, this is relatively low, right? 2 people, more or less, or 3. Rules look good. I mean, You do this for each of your industries over time with the rule reviews? I mean, you tend to have more comments, or is this pretty?
Okay, I think it would probably depend on the program. For the Phase 1 rule reviews, we're probably not going to get that many comments. Yeah. Phase 2, when we do the regular rulemakings, is, depending on the subject matter that's being discussed or considered in the rulemaking, we could get a lot of comments, or we could get just a few.
Okay. Any questions? All right, well, let's go to item H, which is to talk about the possible action to appoint a work group to address new or amended rules at 16 TAC Chapter 94, basically a rule review subgroup or work committee. I mean, I think, in order, we probably need to do that. My suggestion is to put one, if possible, together. And I like, if possible, to have a representative from the public, from the assessor collectors, and from the appraisers, if we get some motions to appoint a work group to do a review, which is part of the Phase 1.
Actually, this would be kind of the Phase 2.
Phase 2 piece, okay. To get feedback on reviewing our rules. A motion for a public member?
I'm willing to serve, if that's your question.
Do we have to have an action item on this, or?
I just want to make that as a
Okay,
motion.
okay, well, so Mike's gonna act as a public member. How about for the assessor collectors?
I'm willing to serve too, or Gary,
We
whoever.
have to have no more, can have no more than 3 members. We can't talk to the other members through this work group. So Sydney, and then, Tim, you wanna jump
Yeah,
in for the appraisers?
Yeah, Tim Radloff, I'll serve as an appraiser member.
So that's the work group. Do we need a motion on this? Or
Yes,
is it?
yes.
Okay, can you get a motion?
I make a motion, Tim Radloff, to create the work group with Mike McDougall as.
Mr. Chairman, you don't need a motion. It's your
It's
call.
Okay.
It's your
Okay.
appointment.
Oh, we're good. All right, then we have a work group. And again, just to, you all will be working together, obviously independent of me and Gary and any other public members that may come on board, because we can't have a roving quorum with regard to this. So in our next meeting, we'll have you all give a report on the rule reviews under Chapter 94. Is there anything that needs to be changed or amended? And I guess at that time, too, you can take into consideration the questions that we received through public comment.
Yes.
Be great. All right, that's great. Let's move on to item I, which is recommendation for agenda items for the next committee meeting. I know that's going to be one. The work group review. And I'm sure I don't anticipate we're going to have a meeting until after the legislative session. So I would think another potential item is post-legislative issues would be something that we probably want to talk about. I know TLR is pretty good about getting the different advisory groups together after our legislators finalize all the bills. So I'm sure we'll be hearing from y'all shortly thereafter, if there's anything affecting us. But those are 2 items I would think we would have put on the agenda. Does anybody else have anything else they could think of?
Not at this time, I don't.
Not at this time.
And I do have a question with regard to that. On setting the agenda up, is it better for each member to talk to TDLR about what agenda items they would want on the agenda itself, or should they come through me? I mean, I was a little, especially with the roving quorum concept, do I reach out to each member asking them, do they have any agenda items they want to be addressed, or is it better to just to come to y'all independent of me suggesting? I didn't contact everybody with regard to this meeting and agenda items.
You can request the agenda items here
Okay.
at the meeting,
Okay,
because we don't want to bring it up.
okay. So this would be the time to do it. And then I guess as presiding officer, if
You
I
have plenty of
choose
time
to,
if you want
I
to
could add something.
more, right.
But it's probably not a good idea for me to call each member before and ask them what agenda items would be
Right.
put on.
Yes.
That's good to know. Okay. Well, with that, I think we're pretty good to go to our date and time. I think we'll just wait until the legislative meeting, session ends.
Mr.
And-
Chairman, staff can get back to you guys individually,
On that.
and you guys can pick a date
Great.
and time.
That'd be great, okay. With that said, we're under adjournment. Motion to adjourn.
Mike McDougall, I'll make that one always.
I'll second.
Thanks.
Sydney Miller, I'll second the motion.
Appreciate it. Thanks. Thanks for everybody coming.
All right. Thank you.
Thanks, Mark.
Thank you.